In the first module, we were able to investigate on topics under the law. This includes the law's origin and evolution, its legal tradition all throughout the history, the wellspring of law or its sources, its purpose and power, and finally, we have also tackled how the law continues to provide a framework for a peaceful coexistence and societal progress. Good day, I am Alvin C. Jr., and upon skimming and critically analyzing the topics altogether, I've had this one big question in mind. Have you ever wondered why laws in some countries feel so structured while the others they seem to evolve with every big court decision? So in these discussions, we track down on the legal traditions that are practiced by different societies in the world to pursue justice, order, and fairness. The world's legal system traces back to what we call Western legal tradition. It's a system that puts law at the center of how society is organized. One of its most important ideas is this: the law stands apart from everything else: politics, religion, even personal power. Courts, lawmakers, and law enforcement are meant to act independently so that justice isn't about who you know or what power you hold. This is where the famous phrase rule of law comes in. No one is above, not even presidents or prime ministers. Within this tradition, there are two big players: civil law and common law. Let's start with civil law. Think of it as a detailed instruction manual for a country. Most of Europe, South America, and parts of Asia use it. In civil law system, everything is written down: codes, statutes, detailed laws that tells you what's allowed and what's not. Judges in the system are like referees. They don't make new rules, they just enforce what's already written. It's organized, predictable, and straightforward. Now, for the common law, it's a little different. It's a system used in places like England, the United States, Canada, and Australia. Instead of relying only in a big rule book, common law is built case by case. Each court decision adds a piece of the puzzle. We call this the doctrine of precedent. What happened in the past helps decide what happens today. It's more flexible because it can adapt as society changes. And it also leans on the jury system, open courtroom debates, making it more dynamic and at times less formal than civil law. So what sets them apart? Imagine you're trying to learn how to drive. Civil law is like a thick driving manual. It tells you everything before you even turn the key. Common law is more like learning on the road. Someone shows you how, you make a few turns, and each experience shapes how you drive next time. Civil law is about structure and clarity. Common law is about growth and adaptability. But here's the key takeaway. Both systems want the same thing: order, fairness, and justice. One gives you a clear path, and the other gives you room to adjust along the way. Together, they form the backbone of the Western legal tradition, influencing how laws are written, interpreted, and lived out all over the world. And as future lawyers, judges, or policymakers, understanding this tradition isn't just about passing exams. It's about knowing the history behind rules you'll one day work with and why they work the way they do.